Good evening, everyone. We welcome each one of you to our Advocate on Record Aspirants Academy. This is our 42nd lecture series, and today's topic is how to draft special leave petitions in criminal matters. Before we go into the topic, it is our usual practice that we recite the preamble of the Constitution of India with a sense of commitment and sentiment, because we strongly believe that preamble is our goal and preamble our soul. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, now the topic is how to draft special leave petition in criminal matters. So before touching upon this topic, how to approach this topic, that is very important. First and foremost is Article 136 of the Constitution of India, which deals with extraordinary appellate jurisdiction. So what is extraordinary in it? When you say he is an extraordinary student, then how is he extraordinary than the ordinary student? If you say it is an extraordinary appellate jurisdiction, then how it is distinguished from appellate jurisdiction? Generally, the appellate jurisdiction, the appeal arises out of the High Court judgment degree, final judgment and degree, and it goes to the Supreme Court. This is what civil appellate jurisdiction is. But extraordinary means even it can be filed against the order of the district court. Secondly, it need not be a final judgment or final degree, it can be any order, be it interim or final order. So therefore, it need not come from the High Court to the Supreme Court, it may come directly from the district court to the Supreme Court. Therefore, it is extraordinary. It is not only the final judgment, it can be an interim order. Therefore, it is extraordinary. So let us read what is Article 136 of the Constitution of India says. It reads as follows. Notwithstanding anything contained in this chapter means chapter 4, which deals with Union Judiciary. So notwithstanding anything contained in this chapter, the Supreme Court may grant leave. It is may, not shall. The Supreme Court may grant leave against any judgment, any degree, determination, sentence or order passed by any court or any tribunal in any matter in the territory of India. So therefore the emphasis is on even interim order also, as well as it arises from the district court also, it can be directly filed in the Supreme Court. Now what is the exception clause with respect to Article 136 clause 1 is, Article 136 clause 2 is an exception to clause 1. Once we say the appeal SLP lies against any judgment passed by any court or tribunal, whether armed forces also covered under clause 1, the answer is no. Because any judgment, any determination or any sentence or order passed by any court or tribunal constituted under the Armed Forces Arms Act, that will not, an appeal will not lie to the Supreme Court under 136, because they have got a statutory appeal under Armed Forces Tribunals Act. So this is what the structure of 136 clause 1 and 2, dear friends. Why such a wide power vested with the Honorable Supreme Court? Next question. Why it has to come from the district court directly to the Supreme Court? Why against any order to the Supreme Court? Reason is the Supreme Court's power is very wide, and if there is an emergency, an urgency in the matter where it requires the direct consideration of the Honorable Supreme Court, then it can be done. There is a possibility. But provided we satisfy the Honorable Court's conscience that why we have not approached the High Court and why there is an element of urgency in this matter. So after reading this article 136, which talks about special leave petition, now we need to move on to Supreme Court rules 2013. This Supreme Court rules 2013 was framed by the Honorable Supreme Court by virtue of Article 145 clause 1 of the Constitution of India. Because be it legislative, executive or the judiciary, they derive their power from the Constitution of India. So Article 145 clause 1 empowers the Supreme Court to frame rules with respect to the jurisdiction is concerned, with respect to the advocates are concerned. So with respect to the jurisdictions, extraordinary appellate jurisdictions, they have framed Order 22 of Supreme Court rules, which specifically deals with SLP in criminal matters. On the previous occasion, we dealt with entirely in detail what is about Order 22. Now we need to apply that in practical, and for which I would like to draw your attention to the previous question papers where they were specifically asked our aspirants or the attendees to draft the entire petition. So what is that question, dear friends, and which question paper that we are going to refer? This is June 2024 drafting paper, in which the section number 2, section 1, question number 2, they were asked to draft a special leave petition in this matter. So what is the facts of the case in this case? The facts of the case is the husband and wife, they were married. Even within 1 year of their marriage, there was some fight between the husband and wife. It was around 5 o'clock in the evening when husband was about to hit the wife, about to assault the wife. The wife was trying to escape from the husband, and she was running out of the home in order to protect herself. But husband did not leave. He was also chasing behind her. And ultimately, he got hold of her and he started beating, and he could find some stones nearby. He took the stones and he assaulted the wife very badly. Ultimately, she died. FIR was registered under section 302 of IPC. And then investigation went on, trial commenced. PW1 to PW3 were the eyewitnesses, and they supported the prosecution case. The trial court found that prosecution case is genuine, and prosecution witnesses from PW1 to 3, they are all eyewitnesses, so they were also worthy, and these prosecution, the trial court has believed that the prosecution witnesses are worth, So they have believed it, and ultimately he was found guilty. Husband was found guilty under section 302 IPC. Now what is the sentence? They have imposed life sentence. So after that, husband is aggrieved. He prefers an appeal before the High Court. High Court also confirmed the life sentence, found him guilty. So it's a concurrent findings. Now he has no other option except to approach us to file special leave petition in this matter. Now you please think yourself that client has come to you and you are an advocate on record. Now you have started drafting the petition. So before starting the petition, what will you do? First, you need to ask yourself how to get the acquittal. That is the best relief that we can bring it to our client. So though there were two courts, High Court and the trial court, have convicted him under 302 and sentenced him to life, the best relief that we can provide to him is acquittal. As an alternative prayer, we can make a submission that he should not be convicted under 302. On the contrary, he may be convicted punished under 304 part 2, culpable homicide not amounting to murder. Therefore, life sentence can be reduced to minimum of 10 years, or the sentence 304 part 2 says it may extend up to 10 years. So it may be 5 years also, 7 years also, 10 years also. Therefore, we can bring it as an alternative relief. Therefore, reduction of life sentence to the, say, 304 part 2, any sentence, maybe 7 years or 8 years, depends upon the merits of the case and the honorable court's discretion. For that purpose, if you want to bring it within 304 part 2, what you have to ask yourself? Death has occurred, but you want to bring it within the bracket of 304 part 2. First and foremost is intention, mens rea. So what was his intention? Did he prepare to murder her for the last 10 days? The answer is no, because there was a sudden fight. So therefore, no intention. In murder, there should be a specific intention, motive, enmity, many things are there. So number one is absence of criminal intention. Number two, he did not murder within the four corners of the wall. She was trying to escape, and he was also chasing his wife. Number three, did he carry any weapon? The answer is no. He did not carry any weapon. Therefore, there is no intention to cause murder. He was trying to beat, he was trying to assault, but all of a sudden he found the stone, he started using it. So, no intention. It was out of sudden provocation. Then no weapon was used, and it was in an open space. So considering this, and where was the injury? Whether there was multiple injuries or single injury. Here in this case, there is only one single injury. On which part of her body? Only on ribs. Not multiple injuries. So nature of injury also important. And which part of her body? That is also important. So considering everything, whether will you fall under 304 part 2? These are the questions that you need to ask yourself. And before you draft, you should get similar judgment, dear friends. Generally, it is said that in criminal cases, no question of precedence. It is only from facts to facts, case to case, that law will be applied by the courts. But for your drafting purpose is concerned, you can take out any precedent cases where there was a fight between husband and wife, where he was sentenced to life and then reduced to 304 part 2. So what are those discussions made in those judgments? If it fits to your case, you can add on to your case as a grounds. So that is how before drafting, you should read what is section 300, exceptions to section 300 and section 299. I'm talking about old IPC, I'm not talking about BNS. Bharatiya Nyaya Sanhita, I'm not talking about old IPC. So 299, culpable homicide. And what is the punishment? Then you have to see 304 part 2 and similar judgments also. So only after studying thoroughly the facts of the case and law involved, then only you can start preparing your draft. You cannot simultaneously draft your petition, dear friends, unless and until you have the enough ingredients to prepare good drafting. You cannot do it. So you need a good preparation. Only when you have prepared well, then you have put it in drafting, and then you can plead whatever you have taken it in the SLP. You cannot argue a case what you have not urged in your grounds, because we cannot go beyond the pleadings. Otherwise the court will ask, honorable court will ask us, where in which ground that you have taken this. If you are unable to show, that means we have not prepared our case properly. So in this case also, how to draft now? I will take you to form number 28, dear friends. Form number 28, nobody should forget this form number 28 of Supreme Court rules, because it deals with format of SLP, dear friends. Form number 28 in the Supreme Court of India. It talks about civil appellate jurisdiction with certain modifications of the rules and regulations. You can make it as criminal appellate jurisdiction. The crucial aspect is questions of law and the grounds, and these two should take us to prayer interim relief also, as well as for the main prayer also. That is our destination. We want the main prayer. What is the main prayer in this case? Grant leave. The Supreme Court may grant leave against the impugned final judgment and order dated passed by the Honorable High Court in criminal number so and so. And what is your interim relief? Because he has surrendered. After the life sentence was imposed by the High Court, he surrendered himself. So to prove the surrender, we have to file the custody certificate. And in the interim prayer, what will you ask? Grant bail in connection with the FIR number so and so, or in connection with session trial case number so and so. So that is our interim relief, interim prayer, because the SLP might take some years. Meanwhile, he may be granted bail. So these are the two destinations where we have fixed in our petition. How to reach the destination? You have to board the train and you have to go step by step milestones from one station to another station. Those are all the grounds, dear friends. So what is the first ground that we will take? Before that, let me tell you how to frame the question of law. That is important. So what is question of law? There is a difference between substantial question of law and question of law. I will give you one example, therefore you can understand. Here, if you look at the grounds, it says only questions of law, not substantial questions of law. There is a difference. In substantial question of law means concerning the general importance, public at large. Here it is concerning only with the party, doesn't concern with the public at large. Secondly, when there is already a guidelines issued by the Supreme Court, we can say that those guidelines were not followed in this case. So in disregard to the guidelines issued by the Supreme Court, so that is a question of law. But you want to make the Supreme Court to lay down guidelines for the first time. it becomes a substantial question of law. So if something we ask the Honorable Supreme Court to travel in an unexplored path, it is a substantial question of law. When already path is paved, only thing is we are requesting to travel. Where already path is made, that is question of law. So in this case, what is the question of law? The first question of law we can say, we can urge before the Honorable Supreme Court is whether the Honorable High Court, because we are finding fault with the Honorable High Court, therefore we are seeking the interference of the Honorable Supreme Court. So whether the Honorable High Court committed perversity, I repeatedly say, and I ask our AOR aspirants also, whenever SLP you are asked to draft, please use this term perversity. That is very, very important. What is perversity? The Honorable High Court taken into irrelevant material, irrelevant facts or irrelevant evidence and arrived at this decision, erroneous decision. That is perversity. Or the Honorable High Court not considered the relevant material facts. That is perversity. In simple terms, it is mentioned as improper reception or rejection of material facts or material evidence. This is what the perversity is. This perversity can be used both in SLP civil also, SLP criminal also. So no distinction. So here what is the perversity committed by the High Court? The perversity is, number one, lack of intention. The Honorable High Court committed perversity by not considering that there was no motive, no intention to murder his wife. That is first. Second is committed perversity by not considering the material fact that he did not carry any weapon at the time of commission of the offense. Number two. Number three, the murder took place out of sudden fight and provocation, not with pre-planned. So this is perversity. And it was only one injury. He never had intention, therefore it was only one injury that which was not considered by the High Court. And that injury was also caused in the ribs, which is not sufficient to cause the death. So therefore, this can be argued for reduction of the sentence from 302 to 304 part 2. But with respect to the acquittal is concerned, there is one material fact which I failed to disclose, dear friends, where I will be dealing with very shortly. So we can urge certain grounds that he has been falsely implicated, if there is a ground that you can make it out. Falsely implicated in the case. Or you can even plead alibi. These are all the grounds for the acquittal, provided the fact supports you. Grounds may be there, whether grounds will fit into this case or not, it depends upon the facts of the case. So falsely implicated, alibi, or many other grounds. But in this case, given case, we can ask for reduction of the sentence with considering the eyewitnesses, medical report, everything, dear friends. So once these questions of law are framed, who will answer those questions? In the grounds, we will be answering those questions. So we will say that the Honorable High Court has failed to consider that the entire case arises out of sudden fight. And the same is evident from seeing the petitioner that he did not carry any weapon. And it was only a single injury and not even on the vital parts of her body. and no criminal antecedents that will come for interim prayer. So this is how you frame the questions and you answer those questions in the grounds, and ultimately for grounds for interim relief, no criminal antecedents, and he is the sole breadwinner of the family. These are all the basic grounds that you can take it in any criminal SLP criminal matters. So please remember, dear friends, irrespective of the fact, you can remember the format and remember the certain grounds, so that will help you in impressing the examiners that yes, he knows something. They are not expecting the complete answer. They want to check whether this person is acting with diligently, and whatever he writes, whether does it come from the clarity of the mind. Because we are not going to talk to them personally, dear friends. Our answer paper is going to speak to them. So make sure that it is very neat and legible. If it is, you have scribbled something where you are making the examiner to undergo a difficult job, that means you will not be getting good marks. You should not get irritated. So make it point wise, and if it is possible, give the introduction and conclusion, and remember certain quotations given by the Supreme Court, key words where you can apply for any case. As far as professional ethics are concerned, I said, remember that preamble of these standards, etiquettes of the lawyers provided in the Bar Council of India rules, that you can write it in any of the, it is common, universal principles. So there are universal principles for all the subjects. You should always remember it. So with this, dear friends, I have completed how to draft this criminal petition SLP.